So I do see 5:30. I'd like to convene this meeting of the Board of Directors for the San Lorenzo Valley Water District for January 16th, 2025. Jen, will you take the roll, please?
President Smalley?
Here.
Vice President Lane?
Here.
Director Hill?
Here.
Director Foltz?
Here.
Director Largate?
Here.
All right, we have all in attendance.
Okay. Any changes to the closed session? John? Okay. Oral communications from the public. I see nobody in the room. I see nobody else online except for Barbara Brenner. Given that, I think we can adjourn to closed session.
Okay.
So
CTV, when we come back, can Barbara Brenner please be promoted to panelist? Thank you.
okay, I have 6:30. I'd like to convene this meeting, or reconvene this meeting of the Board of Directors for the San Lorenzo Valley Water District for January 16th, 2025. Jen, would you please take roll?
Yes, President Smalley?
Here.
Vice President Lane?
Here.
Director Hill?
Here.
Director Foltz?
Here.
And Director Largate?
Here.
All right, we have everybody.
Okay. We have no reportable action taken during the closed session. The changes to the agenda. John, any changes to this agenda? Okay. Oral communications. This portion is for members of the public who want to bring up something within the jurisdiction of the district that's not on the agenda this evening. If a member of the public does, the presentations are limited to 3 minutes. Does anybody want to speak? For members of the public that are online, we have no members of the public in the room. And I see no members of the public putting up their hand to speak. So we will transition then to presentations. We have a presentation this evening on conducting public meetings from our legal counsel. We're going to have the presentation and then a discussion afterwards. So I'd like folks to hold their comments during the presentation, take notes if you need to. And if needed, we can go back to one of the slides, but we'll go through the presentation first. At the conclusion of that, we've agreed that we will discuss until 7:30 unless we conclude sooner. That doesn't mean that we're not going to discuss this again, but in order to be able to conduct the rest of the business items that we have on our agenda this evening, we will take a pause on the discussion at that point. If needed, we'll come back at a subsequent meeting because this discussion that we're having this evening is the first of two or three others that we're going to have also. So we can continue this at a subsequent meeting. So with that, I want to turn it over then to our legal counsel. Okay.
Thanks, Mark. Christina Pritchard from my office is going to be doing the presentation on this this evening. So Christina, I've got it over to you.
Thank you. Good evening, everyone. Let me just share my screen so that you can see.
We've got you. Yeah, her. She's pulling up the presentation.
Okay, can you all see a big gray screen that says White Brunner on it?
We do.
Perfect. So this is a presentation mostly surrounding the Brown Act, but also including just some best practices for meetings. And so it will include also a little bit of discussion on your board protocols and parliamentary procedures. The topics that we're going to go over are the form of government that the district currently has, public meetings, agenda requirements, closed session requirements, teleconferencing or remote meeting requirements, penalties associated with Brown Act violations, and tips to avoid those violations. So the district has a board manager form of government. What that means is under the board manager form of government, the governing body, here the board of directors, is responsible for establishing policy, passing ordinances, appropriating public funds, and developing the overall vision and strategy for the district. The board president then performs primarily ceremonial duties, but does act as the presiding officer of the board and acts as the head parliamentarian for all of the meetings. The elected officials then appoint a general manager, or here now you have an interim general manager who oversees the daily operations and ensures proper implementation of the policies and ordinances established by the governing body. So the manager serves directly to the board and usually has an employment agreement or contract which specifies the specific duties and responsibilities. And ideally, that manager is apolitical. The board functions as a centralized unit, meaning that the board as a whole holds authority collectively, but not one individual board member has any power or authority, except in those instances where the board as a whole may appoint a specific board member to perform specific duties or investigate certain circumstances. A good example of that is when an ad hoc committee is established, which has two board members that are specifically assigned to a project or task and is to report back to the board. The board approves the budget and determines public services to be provided, as well as any taxes, fees, assessments to pay for those public services, and then the policy surrounding how those taxes, fees, assessments are going to be implemented and any necessary policies surrounding those public services. The board's focus should be the community's goals, major projects, and long-term considerations such as growth, capital improvements, financing, and strategic planning. The Brown Act, which was adopted in the 50s, is a safeguard for the public's right to access and participate in local government meetings, as well as protecting the necessary conduct of public business by the board. And so there is a bit of a balancing act between transparency and being able to conduct the public's business efficiently and appropriately. Public decision makers should deliberate and take actions as though they're in a glass house. So full transparency is the goal. It ensures meaningful public access and participation, prohibits secret meetings and secret government decisions for the most part, and requires that meetings must be open and public, held on a regular schedule, and must follow an agenda posted in advance in most circumstances. The Brown Act applies to decision makers, the legislative bodies, and committees of the public agency. So that would be this board, board of supervisors, city council, and their subsidiary bodies, so appointed committees and commissions. And that refers to bodies that are put together for a limited purpose, which also have a fixed meeting schedule and continuing subject matter jurisdiction. So for this board, that's your engineering committee, your environmental committee, your finance committee. Those are all legislative, subsidiary bodies that are subject to Brown Act requirements. Certain appointed committees that would not be subject to Brown Act requirements are like ad hoc advisory committees that have less than a quorum of board members assigned to them and are for a limited purpose and are temporary in nature. So those, you don't necessarily have to have board members on an ad hoc committee. You could have an ad hoc advisory committee that is made wholly of the public. It just cannot have more than 2 board members on it because then you would have a quorum. And so an example of one of these advisory committees that would not be subject to Brown Act requirements would be if you had a committee of staff plus a board member that were assigned to a specific project that was to be completed within 3 months, and they served as kind of an oversight board, or you might have members of the public on that. Because there's less than a quorum of board members, it has a specific purpose and it's temporary in nature. That advisory committee or oversight committee would not be subject to Brown Act requirements. So here we have your general requirements for public meetings. Any activity involving a majority of the board in which issues under its subject matter jurisdiction are discussed, heard, decided, or voted on would be a meeting under the Brown Act. No action or discussion on items not included in agenda can be included in such a public meeting. And it's, like I said before, it's a balancing act of effective governance and transparency. So we'll get into closed session in a little bit, but that kind of falls under the gray area of things that are not necessarily fully transparent, but are allowed under the Brown Act in order to ensure effective governance. So a meeting is when a majority of the board are communicating about business within your jurisdiction, your subject matter jurisdiction, either directly or through intermediaries. It applies broadly to any communications, that's face-to-face, phone calls, texts, emails, social media interactions, informal gatherings. The idea is to prevent a consensus from being formed outside of the formal meeting process. So an example is 3 members of the board meet with staff before or after a meeting to discuss items on the agenda. That would constitute a meeting and is not allowed. And now in that example, I'm referring to 3 board members in the same meeting with staff member talking about a subject. And so a different situation that may be allowed is separate board members individually reaching out to a staff member to ask questions about an upcoming agenda item or to ask for additional information, where that staff member is not sharing any information that any other board member has provided or even sharing that any other discussion has been had. That goes to the diligent preparation for an upcoming meeting and information gathering, and does not, would not necessarily constitute a meeting. So in this scenario, there's a local high school football game where 2 members of a 5-member board are in attendance and sit next to each other and discuss how the agency should spend new stimulus funds. Would this be a meeting subject to the Brown Act? It wouldn't, because we don't have a quorum. So 2 board members can discuss any item within the subject matter jurisdiction of the district without violating the Brown Act. It just cannot reach a 3rd board member or more, outside of a duly public notice meeting, that is. In the second scenario, you have 3 water district board members that attend a social event at the community center and hear public comments related to water quality concerns. Is this meeting subject to the Brown Act? It depends. It may constitute a meeting depending on whether the members discuss the issues and comments at the event, or if one of the members comment at the event while the others are present and the subject matter is within the jurisdiction. Typically, water quality issues held at a community meeting within the jurisdiction where water district board members are in attendance is going to presumably fall within the subject matter jurisdiction of the district, and you would have a violation if any one of those members submitted any public comments at that meeting. Recently, not too long ago, within the last 5 years, AB 992 was adopted and put in place. And it has stricter requirements for social media when it comes to board member communications. So whereas we were just talking about 2 board members being able to discuss something and it not being a Brown Act violation, under AB 992, a singular member cannot respond directly to any communication posted by another member regarding agency business or something that's within the subject matter jurisdiction of the district on an internet-based social media platform. So that includes likes, emojis, anything that would show that that board member had reviewed that comment or has anything related to it. And the reason is because when it's an internet-based social media platform, that is an open platform, and any other board member can see that thumbs up, that like, the emojis, any commentary that's on there, and is presumed to be a deliberation and a violation of the Brown Act. It's best if individual board members avoid interacting with other board members on social media altogether to ensure you don't violate the law. But certainly, if you have a friendly relationship outside of your role as a board member, to be very sure that you are not discussing or posting anything related to agency business with each other. There is a relevant exception, since you just went through an election cycle to these public gathering prohibitions on a quorum of the board regarding subject matter jurisdiction, and those are political activities during an active election. The Brown Act does not constrain incumbents from expressing their views regarding important matters facing the local agency as part of the political process, subject to a few restrictions. Incumbents participating in any political forum, so if they're a panelist at a community forum, for example, they should take care to limit their remarks to the notice program and safeguard due process by indicating that they will keep an open mind regarding specific issues that might become before the board. If a quorum of legislative body members are in attendance, the event must be an open and publicized meeting. And so you could have an instance where you have 3 board members up for re-election and there are 3 incumbents. They could serve on a panel at a community forum and discuss something within the subject matter jurisdiction of the district, but could not specifically relate that back to district business and their position as a board member. It would be more of a First Amendment discussion of their views and opinions as a political candidate. And if you've got other legislative body members there, they could not be serving on that panel as well, or commenting or discussing, because then you'd have a full on board meeting. So serial meetings are an example of what I went over before as far as potentially violating the Brown Act through other intermediaries or even on accident, because it is easy to unknowingly violate the Brown Act when you don't know who your other board members are talking to when you are discussing district business with just one other person. So a serial meeting is a series of communications relating to government business that each involve less than a quorum of the legislative body, but taken as a whole involve a quorum of members. It's strictly prohibited and circumvents the requirement that deliberations be transparent and public. This is, I'm sorry if it's small, I'm not sure how large the screen is that you're looking at, but these are a couple of examples of how this happens. The first is a daisy chain where you've got your first member with the information who then discusses a matter with member B, and then that member discusses it with a third. Right there with those 3, you've got a daisy chain. You don't need the other 2, but if all 5 of you do it, you've got a serious violation. For the hub and spoke, it's more common where you have a staff member in the middle who is corresponding with different board members about the same subject matter. Now, there's a gray area here, and it's just you need to be really careful. That staff member should not be sharing opinions, questions, views that they're receiving from other board members with the individual board members they're speaking with. So if a staff member speaks to member A about an agenda item and member A says that they have specific concerns related to the consideration that's going to come before the board, and then the staff member talks to members B and C and tells them of that concern, you've got a deliberation and a violation of the Brown Act. Conversely, if each individually is just asking questions about the agenda item and there's nothing being shared with the other board members regarding that interaction, that goes to diligent preparation for a meeting and you do not have a serial meeting. So you can see how it could be easy for that line to be crossed inadvertently. This, just to go back, this hub and spoke can also happen frequently with constituents. If some of you are speaking to the same constituents in your jurisdiction and they're expressing the same concerns with you, they aren't necessarily familiar with the Brown Act and may be going to several board members to campaign for the same thing and may inadvertently inform other board members of opinions they received. And so you just want to be diligent in those discussions to, understand who they've been talking to and make sure that, maybe provide them with the information of what a Brown Act violation looks like and that you can't be discussing other members' opinions with them. So here's a scenario: an agenda is posted and the clerk sends the meeting announcement email. A board member responds by email to the entire group that they thought an item relating to water plant upgrades had been decided, and 2 board members reply back that the issues are still pending as a serial meeting occurred. And yes, a serial discussion occurred over pending business, which is a violation. So you'll see, I know from our office, we will send emails to the board, but BCC the individual board members to avoid this exact type of situation so that no one can reply all. And we don't have an inadvertent violation. Well, let's see, I think the next scenario might address that now. So the opposite of this or a something that would not be a violation is if staff is just reaching out to schedule a meeting and there isn't content discussed. So a staff member could email the entire board and say, we need a special meeting on this date and time. Are you all available? And all of you replying all that you're available for that meeting is not a violation. General administrative matters are allowed. So as I said at the beginning, as a public agency, you're required to hold regular meetings. Every year you adopt a meeting schedule and it gets posted so the public knows when you meet to discuss regular items of business. Other types of meeting are special meetings, which are held outside of the regular meeting schedule to discuss specific topics. Emergency meetings, which can be held immediately so long as the majority determines that an emergency exists. The Brown Act defines an emergency broadly, but narrow enough that it has to be something where there's some kind of imminent threat, and it has to be something that's going to potentially interrupt public services or cause a public health and safety concern. And so emergency meetings are pretty rare and only require a 3/5 vote of an emergency situation. Adjourned meetings refer to a meeting that is postponed due to cancellation. So let's say for some reason there's some interruption to your meeting and you need to adjourn, but you want to continue and hold the items of business that were agendized. You can post a notice of the adjourned meeting and the date of the rescheduled meeting. There's a 5-day rule that if it is continued to no more than 5 days from the original date, you don't have to repost the agenda. But if it's held anytime after that 5-day window, then the regular agenda posting requirements are going to apply again. And so that's your 72 hours or 24 hours for a special meeting. General rules for your meetings are that they must be held in the boundaries of the local agency. You have to report how each member votes on each open session item, which requires a roll call vote. That is typically handled through the minutes and does not include consensus votes, though the fact that a consensus vote was taken still needs to be listed in the minutes. Information provided to the entire legislative body must be shared with the public. And so this is really important because it's a timing issue as well. So the public needs to have the materials provided to the entire board at the same time as the board. And so that's why you have an agenda packet that is posted at the same time as it's distributed to the board members, is because of that requirement that if you've got a contract that the board's going to be considering, then when that gets circulated to the board prior to the meeting, it also needs to be available for public review. And posting to the website is sufficient for those purposes. If, for example, something is handed out at a meeting though, rather than prior to, there are different rules depending on where that documentation comes from. So if a staff member or another member of the board hands something out to the entire body at the meeting, there need to be copies available for the public immediately at that meeting. Whereas if a consultant or a member of the public or someone who's not staff or a board member hands something out at a meeting, then it only needs to be publicly available by the next business day. And so that's why it's important that any copies get provided to the board clerk at the meeting so that they can facilitate that public availability process. There are no conditions on public attendance, so you can't require them to sign in, and you can't charge for attendance, and you can't require them to provide certain information like their name or address in order to provide public comments at a meeting. There must be at every regular meeting a public comment period for non-agenda items, and then separate public comment periods for each item included on the agenda. When you have a special meeting, you are not required to have the non-agenda public comment period, only the public comments on the specific special items. And then reasonable time limitations are allowed on public comment. This board has that. Your policy manual states 3 minutes. Some agencies will also put a time limit on their board comments. Has to do with meeting efficiencies in your particular agency. I don't believe you guys have that at this point. For the public comment, you must accept it on any item that's on the agenda before action is taken. And you must also allow an opportunity for them to speak on matters under your jurisdiction, your subject matter jurisdiction. So even the non-agenda public comment, it's not all inclusive. It is still limited to your subject matter jurisdiction. Public comment is an opportunity for statements. It's typically not a debate. Part of the issue with allowing a back and forth between the board and the public is that you have to be consistent and equal. And so if you allow a back and forth between one member of the public and the board, then you must do it for all, and you must do it for each item on the agenda. And so that can make for a very long meeting if that is what occurs. So rules for agendas, I think you guys already know the basics of this. Regular meetings are required 72 hours in advance. They have to be posted in a location accessible to members of the public. If you have a website, you are required to post it on the website as well. And then it must be mailed to those people who put in an annual request for mailing of all agendas. Those annual requests are not automatically renewed. So if a member of the public or media organization or anybody wants the agendas mailed to them, they have to renew their request every year, and it's on a calendar year basis. The district can charge for copies and mailing costs such as postage, but not staff time. Special meeting agendas must be posted at least 24 hours in advance. In emergency meetings, the agenda is posted an hour before, and then if any newspaper outlets or media organizations have requested notice of meetings, you must call them and notify them in any way you can of the emergency meeting. And then post along with it who you contacted to inform them of the emergency meeting. For your agenda items, each item needs a general description. It's 20 words or less usually, but it's enough to adequately inform the public about what is going to be discussed and if any action is going to be taken. It does not have to describe all possible actions relating to the item, just that action may be taken. The board cannot act on any item not listed on the agenda unless it's an emergency item and the board determines by a majority vote that an emergency exists, or that immediate action is required for an item not included in the agenda and that it came to staff's attention after the agenda was posted. And for that instance, you need a supermajority, which would be 4/5. That still requires some kind of imminence, and it can't be preference not to include it on a future agenda. There has to be a potential for interruption of services or other potential harm to the district. Situations where there's a brief discussion are allowed without being included in the agenda. And so this is responses to public comment, reports or announcements, or direction to staff. It's pretty limited. If an item is agendized for discussion only and doesn't indicate that there's any requested action or potential action to be taken, then the board cannot take action on that discussion item. I think we went over this already. And so in this instance, the scenario, the district is considering a contract with a consultant to do a water rate study. And under new business items, the agenda says professional services agreement with Raftellus Financial Consultants, Inc. And is that agenda description adequate? It is not. It is too vague and does not notify the public about the topic being discussed. It assumes that the public knows the business of Raftellus and what they do. A better description would be consideration of professional services agreement with Raftellus to conduct a water rate study. In this scenario, the board of directors may approve a new contract for the director of finance. The description reads consideration of a resolution to approve an employment agreement with Penny Pincher as the new director of finance. Is the agenda description adequate? Yes, it is. Additionally, as a side note, I will state that when you are approving executive employment agreements, there are certain requirements of things that must be stated orally on the record, and that is the salary and benefits specifically. And so that's a good reminder that even if it isn't included in the agenda title, it's still something that must be announced prior to approval of any executive contract. Closed session. So closed session is permitted under specific circumstances under the Brown Act to avoid revealing confidential information that would harm the agency's legal or negotiating position, or to avoid compromising a privacy interest of an employee. The specific matters that can be discussed that are most often discussed are personnel matters, labor negotiations, potential litigation, existing litigation, real estate negotiation, and threat to public services. There are some additional allowances under the Brown Act, but these are your most common reasons for meeting in closed session. Your agenda for closed session must be specific. The description is going to be briefer than your normal agenda items, but it must contain certain Brown Act established language, which identifies the relevant topic and the government code section that's applicable. Disclosure of the action taken in closed session is required in specific circumstances, generally not until action is finalized, but it is and is not required for all circumstances. Some examples that require disclosure are real estate agreements, approval of lawsuit initiation, settlement of a litigation, and agreements with labor unions. In some of those circumstances, the roll call votes are also required from closed session, but that is even more narrow. Here's a couple of examples of appropriate closed session language to inform the public of what is to be discussed. You'll see you've got the topic, the government code section, and then where applicable, where the Brown Act requires it, you may have to include an employee title or an organization title, or if you've got real estate negotiations, it's going to require you to list who you are negotiating with. teleconferencing has changed over the years. So we have our traditional teleconferencing requirements, which have more requirements on the front end of what you're providing to the public, but less on the back end as far as restricting actual remote participation. And so the default rules require that agendas be posted in all teleconference locations, that it identify the location of each member participating by teleconference, and that each location be accessible by the public. And public comment must be allowed at each teleconference location. A quorum of the legislative body must be located within the jurisdiction. And so under the default teleconference rules, all members could be participating via teleconference so long as they meet these noticing requirements and participation requirements, and a quorum is within the jurisdiction of the district. This is particularly helpful in natural disaster situations or when you have certain traffic conditions. During COVID, remote attendance was, the requirements and limitations were updated under AB 2449, which was originally scheduled to sunset upon the declaration of the end of the state of emergency, but was ultimately made permanent. And under AB 2449, legislative body members can only participate remotely for specific reasons. And there are more restrictions and requirements than the default rules. At least a quorum must be physically present at the meeting held within the jurisdiction of the agency. The public must be provided access to attend the meeting remotely as well. The member of a legislative body who's unable to attend in person must show either just cause, and I'll give you that definition in a minute, or emergency circumstances for not being able to attend in person. They must also identify whether there's anyone in the room with them that's over the age of 18 and what their relationship to that person is. And then the member remotely attending must be attend by both audio and visual technology, such as Zoom or Teams. So you have to be able to see and hear them. Just cause is defined as a childcare or caregiving need, contagious illness, need related to a physical or mental disability, or travel while on official business of the legislative body or another state or local agency. Emergency circumstances are limited to a physical or family medical emergency that prevents the member from attending in person. Just cause may only be used. This is just a good little reference for you guys. I believe this was included in the packet, and so this is a good reference for the requirements that just lists everything I already went over. For the emergency circumstance, you have to state on the record during the meeting what your justification for attending remotely is, but you do not have to specifically identify the medical condition or any private information. The body must approve the request for attending for an emergency, but for just cause, there is no approval required. So there's not going to be a vote related to that. For just cause, each member can only attend the meeting remotely twice in one calendar year under that reasoning. There's no restriction on attending under emergency circumstances. However, the law does disallow participation by remote means for any reason for a period of more than 3 consecutive months or 20% of the regular meetings for the local agency within a calendar year. A violation of that could result in an abandonment of office. So penalties for violations, any member of the public or the DA on their own can bring an action for Brown Act violations. It can result in an invalidation of an agency action under certain circumstances. That typically requires some prejudice to the person or entity that's bringing the Brown Act violation action, or some kind of gross conduct as far as, purposely withholding information and government action from the public. There are civil action and remedies as well. Again, that requires some prejudice on the part of the person bringing it. A individual board member could be liable for a misdemeanor or criminal charges. Typically, that requires malicious intent. So there's a knowledge requirement where you knew you were withholding information from the public, or you knew that you were leaking confidential information or something to that effect. The court can award costs and attorney's fees to a prevailing party, not the public entity, just the person that's bringing it. And then, of course, there's always damage to reputation and public perception, and then a loss of public trust in those situations. There is a cure and correct period requirement. And so if someone accuses the board of a Brown Act violation or an individual member, there's a 30-day cure and correct period. If the agency does find that there was a violation, they can correct it, usually through ratification of the action that was taken improperly, or they can send a letter to the recipient if it's not something that's correctable, that they recognize it and that they will prevent it in the future and the steps that they're going to take to prevent it. If there's no response in that 30-day period or a failure to cure and correct, then the person alleging the violation has 15 days from that 30-day mark to file suit. So it's a very short period of time to attempt to invalidate any government action. Some tips to avoid Brown Act violations. Avoid discussing government business whenever around a quorum of the board. And so a lot of times I'll see this just before a board meeting, not necessarily with you guys, but at my other agencies, if I'm there in person, right before the meeting starts, people are milling around and two board members might be discussing an item of business that's on the agenda within earshot of other members. Just be aware of who's around and who can hear you, and that it is really easy to cause a Brown Act violation in that way. Be aware of reaching a quorum through intermediaries. Those are the serial meetings we talked about, through constituents or staff or even other board members. Be careful not to reply all to emails that include all the board members if you do receive them. You may discuss procedural issues, like I said, date and time of meetings. That's really the strongest example of that. Really, staff and your interim GM are the ones describing the agenda items and working through that. It's good to avoid lesser known acronyms or abbreviations, or really just acronyms or abbreviations in general, so that even members that are new to your public, new constituents, know what you're talking about and what is to be considered. Keep meeting discussions to items listed on the agenda. Provide meeting materials to the public in advance. And when in doubt about discussing agency business outside of a formal meeting, contact your main point of contact, which is your interim general manager, or you may contact general counsel. I just have a couple more slides that'll go really fast. And this is just to go over your parliamentary procedures, because they do overlap a little bit with the Brown Act, but they're different. And that they're not by law, they're pursuant to your policy manual. So the purpose of parliamentary procedure is that discussions proceed in an orderly and fair manner. The goal is to keep discussions fair, impartial, and objective, and to allow for due process. So advance notice, opportunity to be heard at public hearings, and full disclosure to the public of all relevant information. This board has adopted Robert's Rules of Order is part of its board policy manual and what guides your meetings. It is important to note that failure to strictly adhere to Robert's Rules of Order is not going to invalidate any actions by the board. They are there as a guide to help meeting efficiency. The basic tenets of Robert's Rules of Order are that every participant is entitled to participate in the discussion. That only one person may have the floor at any one time. No person can speak until recognized by the chair, which is your board president. That your board president is an impartial presiding officer, and that personal remarks are not proper. And to that end, it's just a good reminder, the role of a decision-making body is really two general kinds of decisions and considerations that a legislative body is dealing with. The first is legislative decisions, and that's making or interpreting policy. So when you're passing resolutions, implementing policy, or updating your rules and regulations ordinance, legislative decisions apply to all of your residents and constituents equally, whereas the second type of decision that is placed before you and is not as common as your legislative decisions is your administrative or adjudicative decisions. These are quasi-judicial in that they directly impact a specific person or entity or category of people. And so the best example for you guys is when people are applying for water connections, or when you have a development that is requiring a large infrastructure improvement in order to connect to the water utility. The decision you are making is directly applicable to that applicant and will affect them directly. And so it is a quasi-judicial decision and would not be considered policy. And so those are really your two main considerations. And if they don't fall in there, the question you ask is, do you have the authority to do it? If it's not a legislative or adjudicative decision, then is it something that's properly placed before the board? That's what I have this evening. And now, do you have any questions?
Okay, thank you, Christina.
Sure.
I do want to go back to what I said at the beginning as to taking a pause at some point. The presentation ran a little longer than what I anticipated it was going to be. Rather than 7:30, I'll propose extending that by 10 minutes to make it 7:40, because I don't know if the 14 minutes now that we have left is sufficient for that. So 7:40, we'll take a pause and then go from there, depending upon the questions. So I'd like to go to the board first, and then staff, and then open up to the general public for questions on what was presented on any of the items. So Brian?
I have no questions.
Okay. Elena?
Yeah, I have some.
Okay.
I think in there you talked about the AB 922 and as that pertains to social media specifically. What about newspaper, since that seems to be a popular form of communication for some board members?
Are you referring to like op-ed pieces?
Correct.
Yeah, that's an interesting question. I mean, I would say that if an op-ed piece is posted on a social media site that allows for commentary or any kind of clicks, that would necessarily fall under the prohibition. Because the whole, I mean, the way you should look at it is the purpose of the law is that when you have internet-based platforms that are available, that are publicly available to all, that there is a much higher risk of potential deliberation among legislative body members. And so I would say a posting of an op-ed piece is going to operate in the same way as if that board member just put up a post on Facebook.
Okay. Okay, I also had another question. So I kind of have like three situations for me that require further clarification, and they involve like kind of like nuanced differences. What was some of the actions were kind of permissible while others are not. So we kind of had a situation that happened here where we were going through the throes of, getting the the new general manager in by wrapping up with the previous interim, and comments were kind of made that mischaracterized the situation primarily because a lot of the relevant information was not publicly available. And then we had a director that intervened and provided legal perspective on that to kind of help clarify the matter. However, since that information was disclosed during closed session, like I understand like now why that couldn't be repeated out publicly, but it kind of moves to this second situation where I was like following up, trying to understand that better about what had transpired in the past. And I had, mentioned that there was a candidate form, and I was informed as planned that that would be a violation of the Brown Act, which did align with my previous training that I had received here with the district. So, and I thought that situation resolved. I relearned, real time it wasn't. And then I was advised that I could not discuss the matter further or disclose any legal advice that I had received. So that's the situation one, which leads me to situation three, which is very similar to the second situation, but it had a different outcome. So this is where I really need the clarity. So we had a public comment, and it was suggested that a director should recuse themselves due to a potential conflict of interest. And then in the response, that director stated that they had consulted legal counsel who had confirmed that there was no conflict of interest. So that was a public disclosure of legal advice. So it raises an important question to me, like why were one director permitted to share legal counsel's advice in that instance, while in another we are told that we were not being able to disclose legal counsel advice. So like I understand the first one was close second, and then what's the difference between the next two?
It's about exposure. So there's a difference between legal advice preventing that discusses the potential exposure of certain decisions being made, and legal advice stating what the law is. And so when you're talking about whether a board member needs to recuse themselves or has a conflict of interest, there's nothing in that advice given prior to the meeting that wouldn't be given in open session as well, for the most part. Whereas when we're talking about potential litigation liability or potential legal ramifications that would occur from the various options that are presented to a board on how to handle a specific, very sensitive situation, you can't really discuss that advice in public because it would harm the position of the district in that potential litigation, or similarly in a negotiation that was occurring.
Okay, thank you. That's all I have.
You're welcome.
Okay. I did want to follow up on one of the first questions that Alina asked, but I'll come back to my final questions after Bob and Jeff. Jeff? Any?
I have only one question, and that is, do we have this presentation available electronically?
Yes.
I can load it on my machine and look at it later.
Okay. Do we?
I think we'd have to get that from Christina, but yeah.
I have it. I can
You have it?
disseminate it.
Yeah, okay.
Okay.
And following up on that, could that be posted to the website?
Yeah.
Under the minutes area or what have you?
Yeah.
Yeah, no, I mean, the information is really good. It's very similar to what I've had,
Right.
From other council and other things. So yeah, no questions.
Okay. Okay. The question that I did want to follow up on, Christina, was a question that Elena was posing on newspaper, not social media, but print. Can you address that with a board member offering an opinion, or yes, an opinion on things?
Yeah, I mean, you all don't give up your First Amendment rights when you become elected.
That's my understanding. Yeah.
The issue doesn't stem from the initial opinion piece or even from any one of you stating your opinion on a specific subject. The issue comes in when there are more than two of you doing it in a forum which allows for discussion, comment, or reaction of any kind. That's the issue.
So if 3 board members chose to publish something and put their names on it that were matters of district policy or district matters, sounds like what you're saying is yes, that would.
It depends.
Okay.
Yeah,
All
I
right.
mean, it depends
I'm
on
good
the
with-
content, it depends on the format, and it depends on, you are, as board members, you are required to also be
Yes.
residents of the jurisdiction, and therefore you are very likely customers of your own
Right.
district.
Yeah.
And so, I mean, for instance, when water rates or water quality, that's always going to be within the subject matter jurisdiction of the district. But
Right.
any one board member and any 3 or more, if you each are putting out some kind of op-ed piece or commentary on your own social media that
Right.
says me as a utility user, not
Right.
as a board member, and
Yeah.
you make that very clear that you are not speaking on behalf of the board or as a board member, then it has to be evaluated on a case by case
Right.
basis, but it's usually going to
Yes.
be okay because you're not giving up your right as a resident to speak.
Right.
your
You
opinion.
answered my question.
Yeah.
Yes. Okay. Thank you.
I have one other comment.
Okay.
I believe this is a problem with the legislature, not your slides. But the whole area of holding, a board member attending a meeting remotely, under which circumstance and under which part of the law, et cetera, is all very confusing. And frankly, I think the legislature has done a terrible job of defining
Okay.
that. And I think that's true.
I concur with that.
Yeah,
Yes.
and I think
Yes.
a lot of that's because some of our legislators don't know anything about social media or business, internet or business or anything. So
Right.
that's just
Okay.
an opinion piece there from you.
So we've had questions, comments from the board. Does staff have any questions? Since you are participating in these meetings and at times you're running the committee meetings, we need to keep in mind, and we don't always have the attorneys available for committee meetings. So keep this in mind for those. So any questions from staff about this?
I have one.
Okay.
So it's about the remote locations. I noticed that this is what we had done previously at a previous place I worked at, but if they're not in a public setting where they can post the agenda, then they are only able to participate as a member of the public. Is that correct? So if they're participating remotely from some other location, but it's in a private residence or something like that.
No.
Post it on the house.
Yeah,
Right.
I always say to post it on the front door, and the location is publicly available. And so as long as they know, if a member of the public shows up at their door when it's time for the meeting, they
Yes.
have to let them in, or they're
Yes.
only going to be participating as a member of the public, right?
Right.
I'm always astounded that no one shows up at my daughter's house in Dyke,
Yeah.
Texas when I'm there. It's
Yeah.
like,
Yeah, crazy.
Yes.
Anything else from staff?
On the front door of the Conrad Hilton Hotel.
Anything else from staff? Okay, any members of the public, since this is an item on the agenda this evening?
there are potential committee members on that.
That is correct. And I see no hands up from members of the public. And again, there are no members of the public in the room physically this evening. So I will consider this item concluded.
And you beat the 7:30 deadline.
Thank you, Bob. Okay.
Thank
Moving
you.
on then.
Thanks, Christina.
Thank you, Christina. All right. Let's see, what do we have? The item that all of the potential committee members have been waiting for that have been online. Unfinished business, we have none. New business. First up are the committee appointments for public applicants. John, who's,
I can handle this. This is just a continuance. Remember at your last meeting, we created a new environmental committee, that's a standalone committee. And so, we had to, ascertain who would like to serve on that committee. And so you have, the committee choices, that the public has stated that they would like to serve on. So we, at this point in time, we would need, the board to appoint, 3 members to those committees.
okay. At
Excuse me, could I clarify though? The board policy manual doesn't specify 3.
Correct.
It is something that we set when we appoint. So we have historically been up to 3, but we could go more if we wish.
Okay. I thought the policy manual said up to 3, but if you
Well,
remember differently,
I do, but let's go check.
and while you're doing that, Bob, I also want to clarify, there were, for the public, there were several members that had indicated a preference initially for the combined engineering and environmental committee. Jen, you checked with those members of the public and they can, pardon?
They responded and let me know what they wanted.
They concluded that they were okay with, and I don't remember the names, being on either the admin or the budget and finance committee. Okay. So the ones that we were left with, the board reviewed those applications of the remaining ones, and we made selections. On the environmental committee, the board agreed on Michael Duffy, Laurie Mickelson, and Robert Williams. On the engineering committee, Francis Cleveland, Bill Grace, and Ken Landy. So with that, Bob?
Yeah, you're correct, up to 3. And I will say that was probably a consensus, not a unanimous selection.
I agree.
So I want to make it really clear that doesn't reflect the choices that I had put in. So
I understand.
But that's fine. I understand.
Right, understood. So any further comments from the board on this? Any members of the public wish to comment on what we've put here? Otherwise, I'll make the motion. I do see one hand up. Mr. Smallman. Can he be unmuted?
There it goes.
Okay. You have the floor, Mr. Smallman. Hello.
We're not hearing anything.
Is he muted on his end?
He should be able to hear us.
Yeah, well, that's why I asked the
He
question.
should be able to hear us.
Yeah.
Either that, he's got one-way media.
Nice. Well, I think having that mic shows that he can.
That it's available doesn't mean that the channel is there.
I understand that, but
Yeah, nothing
we've
you can
done
do.
what we can from our end. I don't see that we can resolve his inability to speak from his end. I move that the board appoint the public members, as I've read out, to the engineering committee for 2025, and I move that the board appoint public members as read to the environmental committee for 2025.
I will second that.
Okay,
Can I offer an amendment
sure.
with the words "and set the committee size to 5" for that?
But I don't understand
for the determination of a quorum. Right, because if we don't say that, if we had appointed somebody, let's say we appointed 4 or 3, the quorum varies based on the appointment size. We don't have to do it if you don't want.
So each committee has
Two committee has 5 members.
Yeah. Yeah, it's got 3 citizens and 2 board members, so.
All right.
That sounds like.
Okay.
Yes.
Okay,
Okay,
so we had a motion and we had a
Yes.
second.
did we?
I second it.
Oh, okay, all right. Jen, we take the roll?
President Smolley,
Yes.
Vice President Lee,
Yes.
Director Hill,
Yes.
Director Foltz,
Yes.
Director Largay.
Yes.
Okay, passes unanimously.
Okay. Thank you. Moving on then, the creation of the ad hoc committee. I'll start with this one. This is a recommendation, between, staff, particularly John and myself, to form an ad hoc committee regarding the consolidations of Bracken, Bray, and Forest Springs into the district. The memo contains background information that John and I have been able to assemble over the last about 3 months. It includes a definition of the various phases that the district is now considering, a map that shows the locations of where that work is slated to be done, includes brief summaries of what we've been able to obtain on both Bracken Bray and Forest Springs, informational sources that I've been reaching out to for assistance in trying to help our efforts moving forward. I'm to the point though where I would like some assistance from another board member to bounce questions off of with the, here's what I'm saying, here's the way I think I want to go with this. What do you think? And the ability to do some of the other legwork. I've been spending a lot of my time on this over the last number of months. So with that as the premise as to why I put the memo together, first I'd like to hear from the board as to, do we agree or disagree on the ad hoc committee concept? And then I'll solicit from the public also on that. Because before I'm willing to put out names for ad hoc committee, I want to hear what the rest of the board thinks. Is this an appropriate thing to do? So with that, the district has utilized ad hoc committees in the past. Most recently, the one that I'm aware of is when we appointed 2 members to formulate information, put together solicitation for general manager. Jeff, you were involved in that.
Yes.
And I'll transition to you first to comment on this memo and motion that we're considering here. First, could you comment, since you were a member of that ad hoc committee, was that useful in getting to a point of a deliverable and seeking that? And then 2, what are your thoughts on this ad hoc?
Okay, so first of all, on that committee, it was Jamie and me. It gave us the ability to discuss these issues and discuss resumes and reach agreement between the 2 of us on how we would look at the resumes and present them to the board. I found it very useful. We communicated much more frequently, for example, than on board meetings, because we had resumes would come in, we'd look at them, we'd make some comments to each other, and then we would then present that to the board. And I found that very useful.
Okay.
in this particular case, I think this is not only useful, but essential really, because we have two communities of citizens who have been very frustrated in dealing with us and come to the board with requests. And the board as a whole is not a good vehicle for dealing with the complexities of planning and listing all the deliverables that are needed and things like this. And I think having a couple of board members assigned to meet with them on a regular basis with these two communities is a much more efficient way to gather information, gather consensus among us, and then come back to the board with specific proposals. So I think this is a good idea.
Okay, all right. Bob, you've been on the board longer than Jeff and I. Thoughts on this? Thoughts on ad hoc?
Yeah, I mean, it sounds like it from a workload point of view, it sounds like it's getting to the point where two people would be helpful. I've served in ad hoc committees on the board before too, before you guys were on it, and it is helpful in being able to try to get to a consensus. I did have a question about the remit. Would this be including establishing any kind of policies around these sorts of situations?
Policies around, you mean on
consolidation?
It's my hope that we could get there. Yes.
Okay.
Or that the ad hoc committee.
Yeah.
Not a we, but the ad hoc committee could get there. Yes. Yeah.
Yeah, or at least some structure around it.
Yes. Yeah. Am I setting that as a definitive deliverable with that? No, but that's my hope that we could.
Okay.
An ad hoc committee could get to that point.
Okay, because I think ultimately what we're trying to do here is get the consolidation of Brackenbury and Four Springs done as quickly as we possibly can within the circumstances that each group has and challenges that they're facing. Mm-hmm. And it's likely to be somewhat different for both.
Mm-hmm. I expect it will be different, but I would hope that what we're doing in both cases would serve as a model for the district. Fair. For future.
Yes, fair, because we're likely to have more of these in the future.
Yeah. What I'm expecting.
And some are considerably larger.
I'd like to see us set up a model or a format, if not policy, but at least some kind of guidelines on here's how to approach these things.
Yeah. Okay. No, fair enough. That's good clarification for me. Yeah. No, I think it's a good idea.
Okay. All right. Alina?
I think this is a fantastic idea, and we probably should have done it a while ago just to kind of help move everything along. So I fully support this ad hoc committee.
Okay. Ryan?
Given that it's before us, I am in full support of it, and I think that accelerating the process and having a structured process that can serve as a template for future decisions through policy or procedures, I'm agnostic, but getting this all sorted is very important. An ad hoc committee seems to be how we are solving this problem. I'm a little confused why this is not a staff-driven exercise.
I can address that.
Because I think that fundamentally it's a question of nuts and bolts, whether that is what holds the pipeline together underground or the legal structure or the policy framework. These are highly technical issues. And for such, I like to rely on the expertise of professionals. Volunteer board members are terrific to steer that work. But I really hope that the vast majority of the actual work to ensure professional products, not to diminish anyone's capacity to produce those in their own areas of expertise, is done by professional staff and consultants as appropriate.
Okay. Why not staff? We're limited of staff to be able to do it. This is the kind of work that I did for the better part of the last 20 years of my career, getting to this kind of stuff. So if the board wanted to hire me, yeah, I could be, I could be doing this, but I'm not opposing that. That or our general manager could be someone doing this. However, because John is limited on the number of hours that he has, and ideally, John's limited in the length of time that he's going to be with us. Whenever we find an appropriate general manager, I don't want this to be the knowledge leaves with John when he goes out the door. So for those reasons, I'm proposing board members to carry this ball for now until we get a general manager on board and they have some time. Maybe then I could hand it. Maybe then we could hand it back to them and say, "Here's what we've been able to do so far. Please run with it."
I appreciate that. It's good fortune that you have expertise in this area. And it's just a general comment that we have vacancies on our org chart and we have a lot of work to do. And I think we should be staffing proportionate to the work, not proportionate to anything else.
Right. That's a separate conversation.
Because of the good fortune of having some expertise on the board to deploy.
Right.
Right. But we're not going to be able to solve all their problems that way.
I agreed, but additional staff or the need for staff is a separate issue than what we have in front of this discussion with the memo in front of us.
Agreed. That my only hesitancy in supporting it.
Okay. Then before I make a motion on this, I would like to hear from members of the public. If anybody wants to comment on this, please speak. Okay. Karen Vitale.
Good evening, everyone. Yes, I wanted to, Karen Vitale from Forest Springs. I want to comment on the fact that I think this is a good idea as an interim solution for not having sufficient staff. And I very much agree with Brian on that. It's that and to address the continuity issue. There's no secret here that the last 2 years or even longer than that, the staff disruptions have really hampered this project and the continuity of this project. And so I think this is a very critical approach that to moving it forward that will be useful. I think we have to remember that the ad hoc community should be absolutely engaged with our communities, and this gives us a forum for speaking, and I much appreciate that forum. The comment that we were that it was challenging and frustrating for our communities to have to bring everything to board level. Yeah, that's 100% correct. So we appreciate there being a forum here, which is an extension of the board that's working more on a day-to-day task-oriented basis than perhaps strategic. So much appreciated. I think there's going to be elements of strategy in this work and planning and development. And I think by default, there will be staff members who will be asked questions and those technical questions to help resolve them along with the communities. So yeah, that's all I've got. Thank you. And so just to be perfectly clear, we're definitely in support of this idea of an ad hoc committee.
Okay, thank you. Nicole Lauder.
Hi, can you hear me?
Yes, we can, Nicole.
Okay. All right, great. I just want to say on behalf of Bracken Bray, we are excited to have this ad hoc committee to begin to pick up where we left off 15 to 18 months ago, to have the dialogue to move forward. In particular, Bracken Bray needs to utilize their FEMA funding And we did meet today with the Community and Housing Development regarding the block grant and had some really great news. So for us, we are looking forward to actively having communication so we can get this consolidation moving forward so we don't lose the funding that Bracken Bray has secured for our consolidation purposes. So thank you for agendizing this and hopefully taking action to create this new committee. Thank you.
Okay. I see another hand up. Moises Ortiz?
Yes, good evening. How's everyone doing?
Good.
I'm just curious, is the project just in a planning phase right now? So there hasn't been any environmental?
We've completed environmental. We are now at the point of evaluating how we could, where we need to get money, how we could do construction, and putting some type of an agreement in place, a consolidation agreement between our district and these two other water systems.
And the project is only water, it doesn't consist of sewer?
It's just water.
Okay. And I seen a Gantt chart on the agenda. So is the project, is that Gantt chart, is that those timelines already up?
I didn't put that out as far as the agenda.
There's a different Gantt chart on there. Okay. That's all I had. I was just curious where this project was at.
All right. Thank you. Okay. I see no other members of the public. Wishing to comment. Okay, with that, I move that the board adopt the resolution to establish an ad hoc committee and that the board appoint Bob Foltz and myself to the committee. Bob has a historical knowledge of a lot of aspects that have gone on with the district prior to my being here. In particular, the consolidations or mergers of Felton and Lompico. I find the fact that we don't have staff here who participated in any of those now a limitation. So I hope that Bob can bring that to it, plus his financial expertise that I don't have in this case would assist on how we structure potential agreements. So with that, Bob, any comment on?
Okay, I'll do it if the board votes for it.
Okay. Yep. Okay. So I made a motion. Did I hear? Oh, second. Did Bob second? Okay. All right. Okay.
So does your motion include the naming of the two of you?
Yes. Yes. That's what it.
Oh, that was two separate things on here.
The recommended motion was, I move that the board adopt a resolution to establish an ad hoc committee and appoint Bob Foltz and Mark Smalley to the committee.
I'll second that.
Okay.
Or Bob already did, yeah.
You ready for it? Ready for a vote?
Yes.
Okay, President Smalley,
Yes.
Vice President Lang,
No.
Director Hill,
Yes.
Director Foltz,
Yes.
and Director Legge.
Yes.
Passes.
Okay. Quarterly status reports. We have quarterly status reports for engineering and environmental. The quarterly status report for finance, as John indicated earlier, if there are questions on that, since Nicole is not available this evening due to illness, Heather, I'm sorry, Heather, thank you. follow up with questions back to John.
Yeah, you just forward those to me and I can forward those to her when she gets back.
Right, okay. Questions, let's see, which one were in the packet first? Okay, Chris?
Yeah. I provided the report to you all. I'll just cover a few projects that are pretty relevant at the moment that I find interesting. So first will be the Water Smart grant. We got another $100,000 to replace more meters with smart meters. That's great. And we're starting kind of to communicate with the grant people and get that going. So hopefully we can actually start replacing meters soon.
Yeah.
Next, we have the Local Hazard Mitigation Plan, which is funded through Cal OES, the Hazard Mitigation Grant Program. We are nearing completion of a public draft. That should be released before the end of the month. And then once we have public review, we can go through that. And I'm actually hoping to bring that to the next board meeting, is the public draft, and kind of just have a little presentation of what is included in the plan. And then moving forward from there, we can get it finalized and make sure all the public comment is incorporated into that. And then the last project that we've been working on quite a bit is the Olympia invasive removal. So that is with the RCD, the Resource Conservation District of Santa Cruz County. And we are treating 30 acres within the Olympia watershed property, which mostly consists of removing broom, Portuguese and French broom, and locust trees, a few different species. That has been going on for about a month and a half, and we are about halfway done. And that's exciting to kind of see the progress of all of the broom piled up on the, along the road. We're getting that out of there soon, and just see the crew making progress. Yeah, so with that, I'll take any questions about those or the rest of the items on my report.
Okay, all right. Questions for Chris on environmental? Brian?
So I really appreciate all the work that's going on. I especially am grateful that there's meaningful accomplishments. I noticed that your your department in the organization is missing a position, and especially when it comes to securing grant funds and permits to proceed with projects. I hope that can be filled at some point soon, so that we can continue to make progress on this. I have a little trouble keeping track of where we are on the various projects, and the roadmap I use is the 2021 master plan, which lists a lot of different projects for a variety of purposes. And within the master plan, there's a CIP ID, so an identification code that identifies the project, at least for the plan. I think that some of the projects that you list are also in the plan, but maybe the name has changed, or it's I guess it would be helpful to me if there were consistent use of that identifier with some, I don't know what, asterisk or sub A, sub B, if it's a portion of the project that's in the master plan. And the reason for that is because I'm quite curious about how we're doing towards implementation of the master plan. And of course, there's the sequence of identify the project, characterize it, secure grant funds for design phase, get permits, secure grant funds for construction phase, build. There's this whole chain of events that needs to happen. And it would just be really helpful for me to understand whether we're on track or behind schedule with regard to the implementation as proposed in that master plan.
Yeah.
So anyway, other than that, thanks very much for sharing the update.
Yeah, and I know definitely with a lot of these projects, they are grant related. So like we get our colloquial term for them, whatever we call them, day to day. And then they have their grant term. Then there's probably another project. So definitely understand that and trying to get, where it's easy to understand which project is which and where it's at. You get, yeah. So I'll work on that.
Thank you.
Alina?
Yeah, I saw that you were going for drinking water and PFAS contamination settlement. Is there any risk from the CZU fire? Or there's a specific, or were we just going for that since it was a general thing?
Yeah, so that one is specifically for firefighting foam. Apparently, the foam produced by the 4 brands I listed in there contain some form of PFAS. And so because we had small hits in our system, we were eligible to submit a claim for those.
By hits, you mean you detected some?
Yes.
Section.
Okay,
There have
so
been small detections. I think mostly at one of the well sites. But yeah, we have had hits, and so we are eligible to submit a claim.
Okay.
Massive amounts of money in that settlement. So
Yeah,
we'll see what comes out of it.
okay, thank you. And then I saw kind of like under networks and in collaboration that you had going on there. I was a little surprised not to see like SRF, the Salmon Restoration Federation, is going to be held in Santa Cruz. So just to bring that to your attention there. There's gonna be several relevant talks as far as barriers, fire restoration, and so like in general, I just like would greatly see the value in more training for the staff, in enhancing their career development and all of that. So any more like networking or learning, like I highly encourage if it's appropriate. So and then also the thing I saw. I was really concerned. I think we brought it up before, but the lack of grants that the district is currently pursuing, and you heard this before, but not a lot in the pipeline. It said we only pursued 1 grant last year.
Well, some of them that we pursued were either we got them or we didn't get them, so that moved them into separate categories.
I'm looking at the whole thing. I only saw 2024, but I'll go back.
But yeah, we have that. We released a grant writer RFP, and we're looking to move forward with that as soon as possible.
Okay, that is absolutely exciting news. Yeah, anyways, I kind of touched on the Haven there, and I'm really interested in understanding more of our legalities on that. So I'll be looking for more of that, and maybe it'll come to a committee. So,
and that's a good point on the SRF. We'll actually likely be participating in one of the field tours associated with the conference, and so that was just an oversight on my part.
oh, okay. Oh, awesome.
okay. I don't have any questions. Jeff?
Was that French brome you were referring to?
Yeah, French and Portuguese.
Okay, because French brome is incredibly prolific at producing seeds.
Yes.
So I hope that whoever is doing the removal work is doing this in a way that doesn't just reseed the whole area as you drag the plants out, and because it's incredibly prolific in seeds.
Yeah. That's why it spread so much. Yeah. But yes, we're handling that.
Yes.
Anything else?
No.
Well, following up on that, then one of my questions was whether or not this was going to grow back quickly. Are we anticipating that this remediation is good for a long time or a short period of time?
Well, it really depends on what our follow-up is going to be. We definitely, an important aspect is some of the times people will just go out there and like weed whack it, like cut it, but it grows back from the roots and the roots grow larger. We are completely pulling them out of the ground. And so them growing back should be much less possible. But the ground will still be disturbed. There's still possibility. So we will definitely want to have follow-up people going in there and making sure that we're pulling anything that comes up following that. We'll also, I believe, in the future be kind of revegetating it with native plants to prevent some of that happening. Yeah.
Do we expect the neighboring folks, the broom on the neighboring parcels, because you look at the aerial, it's not just us, it's everything around it. Are they going to, is that going to sort of spill over into the area?
Yeah, no, like we don't expect the neighbors to do anything, even along the train tracks that border their property, it's like rampant. However, the actual area of the property that has high value in terms of protected species and that kind of stuff is kind of insulated from the edges, and that's the area that we're really concerned about. And so we're hoping that by doing our property, we'll kind of have the habitat zone insulated, so it would be harder for broom to spread back there
from the neighboring properties. Right. Well, I guess we'll find out. But I mean, it's a great thing to do. But I'm having battled broom on some property that I have. Man, it's a never ending thing.
You want to pull broom when they're not producing feed. You want to do it seasonally because otherwise they're all over the place. So again, echoing what Brian had said on the amount of work. Also, I find the structure of your report to be a lot easier to follow than some previous reports. So I don't know if anybody else had the same reaction, but I was able to go through things pretty easily. I do also like Brian's idea about for those that have been identified in the water master plan using identifiers. I think a lot of these in here though don't have identifiers, right? That they're sort of standalone. But to the extent you can do that, that would be helpful. Just one sort of meta question. Is there any sort of expiry time in any of these grants that we're getting? Yes. And are we bumping up against any of those expiry times?
Yes, I noted for one of them that I'm requesting I think for the Cal OES, the one where we're burying pipelines, hardening water lines. We have to request a time extension for that one. I think there's maybe one other one where we're getting close.
Well, the key point is you're tracking expiry times, and we'll make sure that we don't lose the money.
Right. No, absolutely. That's we definitely want to use up the money that we have available.
Okay. On the tank design area, I mentioned here that the geotech is completed. I just for disclosure, I live right across from the Highland tank, not plural. Did we no issue with the downhill because that road there is flipping a little bit.
I directed that.
Yeah, we have the geotechnical investigation. I'd be happy to share it with you.
Yeah, no problem. As long as there's no problem on that whole hillside there.
I mean, the site, we have a feasibility memo from the civil engineer, and they're more concerned about the cut slope behind the tank.
Sure. Yeah.
And the recommendation is to build a debris wall that in case the slope has a landslide, that it won't hit the tank, or if there's any staff that are at the tank site, they would be protected. And then we would have to go behind the debris wall and clear that material in case there's a future landslide after that.
The reason I'm asking is that we had investigated doing something on our property construction-wise, and the county nixed it because they said it was in a landslide area, and you could not do any building whatsoever at all on that. Of course, our house is there, but and it's been there for 70 years. So I'm just curious about that because that is right where they said the landslide area was, right where the tank is. So because we were further down. Okay. Let's see here. Oh, on the conjunctive use for the Loch Lomond feasibility study. So do we have numbers yet from Santa Cruz on what they're going to charge us for raw and treated water?
I would repeat again, he's been large.
And the reason I'm asking is that if we don't, I don't know how we come up with a cost benefit analysis on the I don't know how you do anything without those numbers.
So we are in discussions with Scotts Valley Water District and the City of Santa Cruz Water Department. The City of Santa Cruz Water Department is proceeding with an intertie project with Scotts Valley Water District.
Yep, 2026 completion.
It's supposed to
10 million grant.
It's supposed to get started this year, and they are doing a study about the cost of service.
Okay.
Or how much they are going to charge each other for water transfers. And the price that the district would end up paying will also be related to that price.
But that's for treated water.
That's for potable water purchase from the City of Santa Cruz Water Department through the Scotts Valley Water District.
And when do they expect to complete that study?
They are hoping to have it completed before the intertie project is complete.
2026.
Okay.
That was the original schedule, was 2026.
Yeah.
Did that also include a number for raw water? And did they agree to tap in at San Lorenzo Way, which would be the logical place? I wish Heidi were still on the meeting, because I noticed she was in earlier.
Oh, if you'd like, I can invite her to come to one of our meetings for a presentation.
Yeah, back, actually, she is gonna be coming.
That would be helpful.
I agree.
Yeah.
Yeah, because, I mean, literally, guys, we cannot determine whether or not we should do
Yes,
raw or
yes.
treated. So without numbers.
Right.
The next
Yeah.
meeting, she,
Yeah,
yeah, she'll be here next meeting.
Okay,
Oh, good, all right, good. We'll get the
uh,
horse's mouth.
so that will be an agendized item then. Okay, good. Good. Look forward to it.
Progress.
All right.
Okay, and by the way, this seems to be swapping back and forth between environment, because you mentioned some of these things on here, but maybe it's not answered. I will see if I can focus just on environment. Right.
If it's board to continue with the question,
Okay.
on the environmental, at least.
Okay.
Report.
Fuel reduction annual maintenance contract, is that now just to be clear on that, we've done a bunch of clearing around infrastructure in the past. This is a maintenance of that clearing that we've done before. Is that correct?
Some of our pieces of infrastructure have not.
I understand that, but in terms of maintenance, I took that to mean make sure that what we cleared in past years continues to stay clear. Is that not correct?
I think it would be both. It would just be fuel reduction in terms of maintaining what we have previously done, but then also if there's a site of value that, has stuff growing, we're going to go ahead and
but
do fuel reduction.
But that's also been covered under grants.
Yeah.
So it might be worthwhile to separate those two from a reporting point of view.
We have a grant that's coming up that we're going to release an RFP for as soon as we can get it going. And we plan to utilize that fully. And then if there is still work to be done the rest of the year beyond what the grant covers, we'll plan to get a contract for that.
Does the grant allow us to use it for both what had been done before using grant money as well as new stuff? Because usually grants are for new stuff.
Fuel reduction is
they don't care.
Kind of fuel reduction. I believe in the view of the grant. Like if we're doing work to protect our infrastructure,
they don't care what. Okay, excellent. I'll wait till the engineering on the Felton Heights.
Well, I'm going to go to engineering next. Yeah.
Habitat conservation plan, the HCP I think we're in our 8th year. Are we really coming to an end on this? Does Jody have a delivery date yet?
I asked her if this schedule was still reasonable, and she said yes. I have been following up with her more regularly to make sure that we are staying on track. And now that we have the ropes and offsite mitigation included in our HCP, there is somewhat of a goalpost to aim towards, or like a timeline kind of attached. So I'm hoping that drives a little more urgency in terms of getting this done as well.
Okay, but I want to move from hope to commitment, because hope is not a plan. Because this has been going on way too long. This needs to wrap up and get done. We need it for not only this, but in the future, we need this thing done. But we're not doing things on an ad hoc basis every time, because it costs more money to do that. So
absolutely.
So I did want to touch briefly on the PFAS. You said we had hits, but given that people may hear this, is the acceptable level of that 0? Or is there a level at which, and we're still under? Because I want to make sure people are not saying, hey, your water's contaminated.
Yeah, so that would be more of a water treatment question. And I have worked with them on this reporting. The levels that we are picking up on these hits are minuscule. However, they are still hits. So it is still recognized. I am not familiar with the MCLs,
What is your research that and bring that back to some
or have somebody from water, or have James come back or something. Yeah, because I think it's really important here to make a clear statement to the community here.
It may have been detected at the well site, but if it's not coming out at the treatment plant, that's a different issue.
Right.
So that's what we need to be focusing on is here's your water quality report, citizens.
And the reason I'm asking for this is I've seen a couple of social media posts on this from in our community, and so I know that it's out there.
Good. I want Jesse respond to that. These are water.
Yeah, and just bring it back to a subsequent meeting for a brief, 2-minute comment on it.
I'm not sure if that also is reported on in our yearly water quality report.
If not, it needs
probably does. But since you brought up PFAS and where you found it, just bring it back at the next meeting and wrap that up.
Okay, so I'm again, Chris, report big improvement from my perspective. Thank you very much for taking the time to put it together. It's very comprehensive. I do have one other question, but it's more engineering than environmental. So wait,
we'll go to that in just a minute. Okay, I don't have any questions on environmental. I'm sorry. I'm going to cover engineering first, and then I'll go to see if anybody from the public has questions on either engineering or environmental. The engineering department report. I want to start with this one. On page 25, 26, you talk about the bridge evaluation. That it's in progress. And I was pushing Sandus. If there's a no-go, can they give any feel from them yet as to whether they're seeing the fatal flaw or?
So the preliminary results of the bridge structural evaluations are supposed to be prepared by the end of this month.
Right.
So that's when we'll know if it's a go, no
go. Okay. They're preparing it, but they must have some idea at this point. Then
you're looking for.
I'm looking for folks. Stop work on writing anything. Yeah. If that's the case, if they're going to give us a 12-page report to say this is bad, don't do it. I want to know sooner than they're finished writing the report.
This will be a preliminary.
Yeah. Okay.
So this would be the first indication of whether it's a
then
go,
the preliminary is going to tell us it's okay, right, Garrett?
We'll see what they say.
No, I want you to go back to them before they finish writing their report. Once they are done with their analysis, they know what they're going to write.
I don't expect a complete analysis at the end of January. I expect preliminary information.
Yeah. So if what they're going to tell us in the report is not good news, I'd like you to surface that before they begin their writing.
Okay, I'll tell them no writing, just results.
That's not what he asked.
That's not what I'm asking. I'm asking you to have a conversation with them. Go talk to them before they start writing to get a sense. Are you gonna, when you write the report, say, don't do it, or
maybe my wording was unfortunate to say report. Right. I just expect a Zoom call meeting.
Okay.
With Sandus.
So that's what I'm.
And the structural engineer to discuss the preliminary results.
Preliminary findings are going to be like those things. Okay.
Correct.
Okay. All right. Yes. Okay. I overinterpreted then what we were going to be getting at that point. Okay. The next that I had was on for the DWR grant for the tanks. It's on page 26. But I see the grant is for 6 tanks. Is the way I've seen the grant described for us. And what it's saying here is that feasibility memos are for 3 tanks, and we're at the costs already over that. So are we putting any work on the other 2 or 3 tanks? So I'm not sure which. Are we putting any further work on those on hold for now?
The south tank design is on hold.
Okay. What about Felton Heights?
We have a feasibility memo for Hilton Heights, Lost Acre Drive.
Okay. Do we have money to do the work?
We have money to do the design.
Okay. And that's within budget then?
For the design, yeah,
Yeah.
we can,
Okay.
we can do the design for
Okay.
hopefully all the sites. So they're
All
at
right.
least shovel ready
Right.
when we have money for the construction.
Right.
Ultimately, the construction costs will have to be discovered through an open bid process.
Agreed.
And at this point, they have a lot of fluff in their cost estimate about the 30% contingency and a 5% escalation.
But for right now, I think what you're telling us here is we're likely to be able to build 3 tanks. You're not sure about the other 2 or 3.
Correct.
Correct. Okay. All right.
And I would also like to point out for the Lost Acre Drive site,
Yeah.
the district does not own the land at the proposed site at this time.
Understand. Right. Okay.
So that's another hurdle. If we're serious about building that tank, we will have to do a land acquisition.
Yeah.
Or easement.
Right.
Same, it costs money.
Right.
To do an easement.
Yeah. Okay. Those are the questions that I have on engineering then. Jeff, some fine questions. Bob?
Yeah, I had a couple. On the Highway 9 paving,
Yes.
I thought that our vote was for lowering. Did that also include raising? Were they kind to us? Or are we spending another 100 and some thousand that need to come to the board here for raising?
So the contract was for lowering and raising.
Yeah.
Cool.
Oh, contractors got to go out and do this.
Yeah, no,
It's already complete. I don't know if you've noticed.
Oh, no,
The paving looks nice.
I've seen.
Concrete rings around the belt boxes.
Yeah, no, it's all looks great.
Yeah.
Actually.
And it's so quiet when you drive up.
Yeah.
Right.
I would comment that there is one manhole, which is not ours, but
Right.
there's one manhole down there that is not filled in yet.
Oh, I
And I
know.
hit it.
Right by Intertie 6.
Yeah. Bob?
Let me see if I can provide a little bit more clarity around numbers on the tanks. So the original numbers that we were given, as I recall, was 6 million to do the tank. We got a 75% grant at 4.5 million. I think that's the numbers come out on that. What I'm hearing here, and this is one of the reasons why I think it's very that if this board is going to depend on grant funding for its capital improvement plan, we've got some issues because this grant is going to be nowhere near enough. I mean, it by the time we get around to doing this, it may not even cover 75% of pre-tank.
Right.
Half.
Right. Right. And I'm not meaning to imply that we're not going to do the other tanks. I want to know what we have still in budget at this point. I would hope that other tanks are part of a subsequent capital improvement plan, but that's a separate discussion that I didn't want to go into.
This is why we need, and I know John and Heather are working on it, the cash flow forecast that needs to be at least 5 years, preferably a little bit more. And it needs to make the assumption, in my opinion, that we're not going to get a lot of FEMA, particularly with everything that's happening right now. We're not going to get a lot of FEMA attention here for probably a couple of years, 3 years, 4 years, who knows how long. That we are basically on our own at this point in time, which for better, and if we get any FEMA money in, great. And when it comes to budgeting for these things, we need to make those kinds of assumptions. Same thing around grants. There's going to be a lot of competition for grants here, guys, in the state of California. And our fire is in the rearview mirror, fortunately, for grants type stuff. So all I'm saying here is that we need to be really clear about what our objectives are going to be when it comes to budgeting for these things. Not meaning to debate the issue right now.
I didn't want to go into what should or shouldn't be in budget. So yeah. Anything else on the engineering?
Yeah, 2 more things on the Felton Heights. Have meetings been set up with a guy for either an easement or a purchase? Where are we on that? Because this is we're in our 12th year, I think, in this.
Yeah, so the feasibility memo gets into some of the finer points, including a site plan, and that's being reviewed by district staff. We do have some review comments about the right of way for a future road that actually, I think it goes over to Felton Empire. And so we want to stay out of that right of way with our improvements.
We do.
And we have a contact in the neighborhood who's acting as the neighborhood representative. We had a meeting with him today about the preliminary site plan. And he's interested in setting up a meeting at the New Felton Library and sharing after the district staff provides review comments on the site plan and it's updated, then he's gonna distribute that to the neighborhood for comments and questions so that staff can prepare responses and then hold the meeting.
When in this process do we actually meet with the owner? Have we done appraisals? Have we?
We've met with the owner and he has some specific concerns. He has a very large parcel and he has concerns about his tax liability. He also has concerns about the impacts on the neighbors if there were some kind of tank rupture and all the water flows downhill.
But we already dealt with that, I think, in the design, right?
So the purpose of the neighborhood meeting is to address concerns of the downhill neighbors so that the neighborhood supports the land acquisition from the large parcel owner.
And that is then the gating item, is if the neighborhood is okay with it, then the owner would be more willing to enter into negotiation.
He is very concerned about his tax liability. He's concerned about the liability if he grants us an easement and something bad were to happen, and he thinks he will get drawn into it.
Well, that's what indemnification is for. I mean, he should be familiar with that, I hope, at this point. Okay. Have we had an appraisal done on the amount of land that we want to acquire?
No.
Okay.
Could I ask a quick question on the tax liability issue?
Yes.
Is he talking about property tax or is he talking about an income, some impact on?
He's concerned that his property tax would be reassessed.
Okay.
If he were to sell us a piece of his property.
Okay.
Or if we were to get an easement.
Yeah, because, if he sells us a piece of property, there's also some profit he'll make on that presumably, and there'll be an income tax.
Well, yeah, but I mean, income taxes, I mean, it's going to be de minimis at some level. Okay, I think I understand where we're at. It's, I mean, this is, so the other thing is that road that's there, that used to be the road actually for accessing that part of Felton Heights from Felton Empire. That used to be the road, not the paved road now.
Oh.
So that's why everybody is very cautious about making sure we don't encroach, because that is also an emergency exit route now. Mm-hmm. So anyway, just FYI in background, I've met with a number of the guys up there. Last one is on tank coatings. So our 30 plus tanks are, everything looks like it's on hold. Is that due to funding or is that due to other aspects? The thing I'm worried about is when I see design and construction after design build on a tank, it sounds like that tank's in need of pretty serious repair.
So I try to organize the projects into projects that are in construction, projects where we have the design completed, where if we want to put out a bid package, for instance, the California 9 bridges, the bid package is on the website. We could put those projects out. Projects in design, we're still waiting for the final documents that we could use for bidding. Projects that are awaiting design means that we haven't engaged a designer or haven't had a specific staff member that's working on that project actively.
Okay. Got it.
So
So what is involved in getting a tank ready to be recoded or to send a bid package out for some of the bid and recoding?
we would put together an RFP that would indicate the scope of work. If we need to add vents, if we need to do repairs, as far as if there's portions that we need to replace, or if they're just going to sandblast and coat.
Do we specify what it is that needs to be done as part of a visual inspection of the tank?
We would specify that in the bid documents.
Okay, so we would say it needs to be sandblasted and recoated. It needs to be repaired in these areas.
Correct.
And we base that on the fact that we've done a visual inspection of it.
I would base that on interactions with operations and any reports we have on the current condition of each tank.
Yeah, because it sounds like in those, it could be very easily get into a real change order type situation. If what the reality is of the tank, once they get in there, is different from. So that's why I was interested in how much visual inspection we do of that in order to support the bid package. Do we drain the tank and look? Do we send scuba divers down? I mean, what do we do?
Divers would enter the tank to make us a report on the condition.
Okay.
Yes.
Okay. And so that hasn't taken place yet either. Then.
We have reports. I'm not sure how current they are. Most of these projects, we had the CIP budget from 2023, and that had, I think it was like 53 projects on it, of which we've completed, I believe, about 14, and some of them are grouped together.
Yeah.
And then 17 of the projects I know specifically I've added. For instance, Stewart Street Pipeline Project, I believe that's a FEMA project. Bennett Spring Raw Water Pipeline. That's when we're doing the environmental work right now.
Excuse me, Garrett. Were tank coatings part of the CIP?
Yeah. So
why don't Brian's suggestion? Let's start using IDs here. So we can cross-reference. I think, Brian, you're absolutely right. We need to be able to cross-reference.
Otherwise, we don't know what we're doing.
Right. And so that would also flow through to the cash flow analysis, making sure we're using the IDs and all that so that we can really get a handle on what we need to do. Okay, great. Perfect timing. Thank you for.
I was excited to take over.
Alina, any comments on engineering?
I guess I overstepped when I said the Haven since that was on my notes. So I really would like to understand the legalities around that whole sphere of influence. So I hope that comes to something like the admin committee so we can take a quicker look at that. And then I just wanted to note that grants are not just tied to the CZU fire. We have the passing of Q, we have Prop 4. Those are all things that we can go for grants. Millions are brought in by other water districts. They have entire departments around grants. Scotts Valley here locally, they got 10 million for an intertie, 10 million for a new well. So we do really need to be aggressively pursuing grants where we can and not leaving any free money on the table and taking that pressure off of our consumers. So that's all.
Right.
I just want to say thanks so much for the update. It's really exciting how much progress is happening and that the gears are turning. In light of the tragedy in LA and the issues of that community, the challenges related to firefighting, and conversations I had a couple months ago with folks, customers of Big Basin who had hoses run dry during the fire. I remain concerned about what's going to happen when the next one comes to us. And one of the specific concerns I have about the naming conventions and keeping track of which project is which is related to the master plan's identification that the majority of our fire hydrants have inadequate fire flows, and they would supply too little water to fight a house fire, let alone a wildfire. a recent conversation with a Felton Fire fighter indicated that they've assumed the hydrants won't work and just bring their own water. And that's, for me, that's not the role I want to play in the community. And so one of the ideas that would help me understand where we are and what kind of decisions we might try to make in terms of planning and budgeting, et cetera, is the master plan has a roster of maybe 20 projects, priority projects to address this fire flow shortcoming that we have. And I think a number of them are the ones that you're installing, which is super exciting, but I don't know which ones. And I search the name and I'm not sure it's the same one. So I'll just reiterate my request that it would be really nice to have this correspondence with the code numbers between the master plan and the projects, and then having a really clear sense, maybe in table format or whatnot, of what the phase is and what the next step that's not already planned is. So you've got to design if the next step is secure funding or allocate funding, and what the strategy is. Is it a grant thing or a bond thing or a budget thing? How is it going to be resolved? And then ideally the target for implementation. Having things organized in that way would do a lot for my wrapping my head around what is the gap between where we want to be and where we are, so that we can make sure that the staff has the resources needed to get there.
Sounds great.
Okay, thanks.
Mark,
Okay.
or can I offer one additional comment when he's done, if he's done?
Brian? Hey,
That's all I got.
okay. All right.
Okay, I mean, this may seem too simplistic, but again, for the community out there that may not understand this, the issue isn't just the hydrant. The issue is the pipe. Correct? In terms of being able to do fire flow.
It's the storage, it's the diameter of the pipe,
Right.
it's,
Yes.
and having
The whole bit. Okay, so just to put this in perspective, 50% of our pipe is 4 inch. That's from the water master plan inventory. 50% of our pipe is 4 inches or below. Those are, I believe, not satisfactory for a fire flow, an adequate fire flow. Am I correct?
our hydrants are
And I'm talking,
6-inch lateral.
I understand that, but for the 50% of our pipe that's 4 inches or below, those aren't adequate for fire flow. Is that correct?
Mm-hmm.
Yeah. So really what we're talking about here, folks, isn't just dealing, and just again, we may understand this, but for the community, it's not just the hydrants, it's everything in the system behind that. And with 50% of our pipe, which totals somewhere around 175 million in replacement cost. Yeah. Okay, so that's what we're dealing with, folks. That this is why long-term planning and cash flow and all the rest of it is so critical, along with everything else we've talked about.
Yeah. Okay, I think we're done with engineering comments. Public questions on either the engineering or environmental reports. I do see Karen Vitale hand up.
That may be a legacy.
I think could be, but I'll ask her.
No, I'd like to speak.
Yes, please.
Oh, okay. All right, I didn't realize I was unmuted already. Thank you. Yeah, I had a couple questions. On page 23, Chris, you've put in a table that lists all of the grants that are sitting there. I know Alina alluded to the table earlier. I see that the Drinking Water State Revolving Fund application is just neatly categorized as sorry, rejected, no money coming until you start construction. I'd like to put that on the list of tasks that the ad hoc committee addresses, to go back to the state revolving fund and see if there is a way we can get some planning grant money, because I do recall being told at one point it was because we asked for too much to start with. And the amount that was asked for, I think, might be more than we actually needed. So we may be able to do ourselves some benefit by revisiting and reapplying.
Note taken, Karen.
Okay, thank you so much. And I really wanted to say that, Chris, I understand that the department is really short-staffed and that grant writer is going to be very important. So yeah, very definitely. I think there is grant money out there and we've got to do everything we can to capture it. And I know that is part of what was discussed for the ad hoc committee for the consolidation as well. But I think there's a global issue here.
Yeah.
Okay, with regard to, so Chris, I guess those weren't questions, but I kind of punted it to someone else to take care of it. So I think you ended up okay on that. On the engineering report. Oh, and I do want to say that it's obvious you guys are juggling a lot. So no doubt, quite a bit. On the engineering report on the consolidation, Garrett, I know you've said that you'll issue the notice to proceed and schedule pre-construction meeting as soon as possible. What is gating whether you can issue that notice to proceed?
So we've executed the contract. The district has 60 days to issue the notice to proceed. We are in communication with the contractor and I expect to issue the notice to proceed hopefully next week.
Next week. Okay, so that's an aspiration date, but pretty quick. You're going to be coming up on your 60 days. So either way, you're going to get that done quite soon.
Yes.
Okay. Yeah, I think that was pretty much, those were my questions.
Okay.
Thank you.
All right. Thanks, Karen. Okay. I see no other questions from the public. There's nobody else in the room. I'd like to then move on to the consent agenda. Does anybody want to poll the board?
No.
Board meeting minutes from? Good. Okay, then we will consider that adopted. District reports. I've got a plaque somebody put on front of my seat, Chris, that is for the green business, certified green business. Can you tell us what this is?
Yeah,
sure.
So the district's main office is a certified green business. The program is run through the county, and me and Jen were at the county office earlier this week at a kind of celebration recognition event for all the green businesses in the county. So we got to meet with our local representative, shake hands, get a picture, and yeah, just kind of meet with all the other people and get recognized, which is great. The program in general, we were certified in 2017, and then we recertified in early 2024. There are like 7 categories that this is based on, which are energy, pollution prevention, solid waste, transportation, wastewater, water, and community. And in order to get certified, we implemented changes like we got 6 kilowatts of solar panel arrays. We upgraded building fixtures and appliances. We reduced our energy usage during peak events through a program through our energy provider. We implemented energy efficiency upgrades, and we purchased 100% renewable energy for that main office. So those are kind of some of the changes that, we implemented in order to get recertified.
So does having this give us another point on some submittal for a grant? Does it allow us to have a box checked, or is it simply we get to hang this on the wall?
Well, we get to be a leader in our community in terms of implementing sustainable practices.
Right.
But yeah, it could be leveraged to do whatever you want. If you want to say you're a green business, so you are more deserving of a grant or something along those lines.
Right.
Sure.
Right. I don't know if the grants that we're applying for, if this is of any impact on those, but okay. All right.
I would certainly mention it on every grant application.
I'll make sure we bring it up.
Okay,
Oh, by the way.
okay.
Let them say no.
I'm not aware of anything else, John.
No,
There's nothing else listed here.
The pictures that came out great. They'll be on your tidbits, and so the
Okay.
public will be able to see them. But it was just great to be recognized, and it did happen at board.
We will be
board
doing a
supervisors.
social media post too.
Okay.
Okay.
Actually, I
Alright.
have a little chart that was pulled from our recording, so I can pull it up. That shows, well, that's a little rough. But basically it just shows our stats on what we've accomplished. So it says since 2017, we've saved like 220,000 pounds of CO2, you know, like 370,000 gallons of water. And it overall adds up to like $25,000 in savings that they are able to kind of accumulate from all of our different categories. It's a very rough estimate, to be fair, but yeah, it's good to be doing something good for the planet and good for our, you know, our checkbook.
Okay. All right.
Good work on that.
Yes, good work. We have no written communication, no informational material. With that, I would like to adjourn.
Okay, UCTV.